हाँ जी सर, ये आपके। हाँ जी, हाँ जी, आप बुला दीजिए। प्रेरणा मैम, आप नीचे जाइए। प्रोफेसर अजय रंगा से आलोक आप ले लें एक बार, ताकि इसको साइड में रख लें। सर ने क्या ये प्रेजेंट कर दिया है? एक दो और पेंटिंग्स है हमारी, जो सुभाष अग्रवाल जी, एक मिनट। एक्चुअली द आर्टिस्ट हैव बीन वेटिंग सिंस मॉर्निंग, तो हम चाह रहे थे कि एक बार उनको बस ऑनर कर दें। ये अलग अलग सबसे दिलवा, सबसे दिलवा आप हम इनके नाम मुझे I would request some of the faculty members to no, I want their names. आप कृपया अजय रंगा जी को मैं कहूंगी कि शॉल प्रेजेंट करें हमारे तीनों आर्टिस्ट को। हमारे साथ आज झूलना के पार्टिसिपेंट्स और परफॉर्मर्स हैं। इसमें सुभाष अग्रवाल जी जो है मथुरा अखाड़ा के चीफ, वो हैं। अम, तुला अखाड़ा से भी हैं लाल सिंह जी। और उसके बाद हमारे एक पुन्हाना अखाड़ा से हैं। ये झूलना में हमारा परफॉर्मेंस रहेगा शाम को। मैं प्रेसिडेंट यूनिवर्सिटी जेसी बोस यूनिवर्सिटी से आग्रह करूंगी मिस्टर नितेश से कि सारे स्टूडेंट्स में ये मैसेज पहुंचवा दिया जाए। आप यहाँ हमारे डिपार्टमेंट के स्टूडेंट हैं और डिपार्टमेंट का प्रोग्राम है, तो सारे स्टूडेंट्स को कहिएगा कि दूर दूर राजस्थान, हरियाणा के दूर दूर के देश, जगह प्रांत, होडल, पलवल, पुन्हाना, यहाँ से आर्टिस्ट आए हैं। तो ये परफॉर्मेंस 3 बजे शुरू होगी, इसको जरूर देखें। इसके लिए हमें ज्यादा से ज्यादा लोग जोश में अ, हमारे आर्टिस्ट को स्वीकारें और उनका सम्मान करें, ये हम चाहते हैं। थैंक यू। अब हम प्लेनरी सेशन की तरफ चल रहे हैं। एडवोकेट जितेंद्र गुप्ता से आग्रह है that he should take over the dais and begin with his talk. This would be followed by Professor Jyoti K. Verma.
Good afternoon again. So before I come to my technical topic on media narrative, I'm sure this issue must have been directly or indirectly covered by the previous speakers in the previous sessions. But what my experience with the media narrative is that media generally does not pick up positive things. You would not see that media picking up positive things, whether it is about the government, about the organizations, because that they assume that that's a given thing. They are obligated to do. A government has been elected for governance, so if a government is doing something good, doing some governance, then it is not newsworthy. It doesn't get covered except as a press release, and the people do not get attention with it. Let us, for example, see what has happened in the we'll read about the mismanagements, we'll read about thefts and the latest controversy which concerns the Galgotia University. So the entire narrative seems to be taken away by media, not on the issue of positives, but on the issue of the negatives. And that is what has always been there. Now, Coming back to my topic, which is the climate litigation and its interrelation with media narrative. I feel that the climate narrative and the climate litigation and media narrative, they are in a kind of a symbiotic arrangement with each other. The media covers, when the media covers the litigation related to the climate, it reaches out to the civil society, and the civil society, two things happen. One, they awareness is spread, and second, more people are motivated to be concerned and to fight for. So it also triggers a kind of a future litigation. And likewise, not all litigations get covered in media, but if there is some litigation related to something very big or very substantial, which is affecting the rights of the masses, then media is bound to cover those litigations. If I go to our own original Vedas, then a verse from the Rig Veda, it states that sky is like the father, the earth like the mother, and the space as their son. The universe consisting of the three is like a family, and any kind of damage done to any one of the three throws the universe out of the balance. Likewise, the Yajurveda declares that the whole university is full of energy, and any imbalance in the energy will lead to natural disturbances like rain, uh, drought, flood, etc. So, the climate change and the impact of climate change can be discovered in our Vedas itself. In the media narrative, as I told you, the recent, even before the year 2025 concluded, you would have read about this story that when the Supreme Court had accepted the change definition of the Aravali Hills and Ranges, wherein it could have increased the development in the Aravali area. There were widespread protests by various stakeholders, the environmentalists, and ultimately the Supreme Court had to stay the implementation of its own judgment. So the climate litigation and the media narrative, it was evident there. Again, very recent example in January 2026, when world leaders were gathering at the uh, World Economic Forum at Davos, then Geeta Gopinath, a former IMF chief economist, surprised everybody when she said that for India, the greater economic threat is not the trade tariffs, but their environment. And it raised a big question mark on our commitment to the climate change and the sustainable development goals. As per the WHO report of 2020, India accounts for 40% of the world's most polluted cities. World Air Quality Report states India is the third most polluted country in the world. And in that same report, New Delhi was declared as the most polluted city globally, capital city globally. And even in case of water, our own Central Pollution Control Board report says that there are 296 polluted river stretches, largely concentrated in urban and industrial zones. The United Nations Sustainable Development Goals for the 2030 agenda are looking for a better world, a more sustainable world, and they are structured around 5 P's: the people, the planet, the prosperity, the peace, and partnership. SDG 13 is on climate change, and SDG 16 is on peace, justice, and strong institutions. So, again, an interrelation between the SDG 13 and SDG 16 is very important. Now, unfortunately, India does not have any specific law on climate change till date. We have an Article 48A in the Directive Principles, which mandates the state to protect and improve the environment. We have a fundamental duty in Article 51AG, which imposes a duty on every citizen to protect and improve the natural environment. But there is no enforcement or there is no teeth to the directive principles or to the fundamental duties. Ultimately, the entire jurisprudence changed when in 1980, the Supreme Court of India held that the constitution right of healthy environment comes from Article 21, which is the right to life and right to live with personal liberty. So we need to remain realistic that while litigations has happened for last 45 years, 46 years since that period of 1980, but not all litigations are successful, because many a times the people are litigating either against the government or against deep pocketed corporations. So it's sometimes an uneven battle where they are not able to win. But even then, a failure at one point of time has been seen to be a success story for another point of time in future. Some of the interesting litigations as they evolved. In 1991, the Supreme Court in the case of Subhash Kumar versus State of Bihar held that the breach of right to a healthy environment could be litigated through PILs. Then again in 1995, in the state of Himachal versus Ganesh Wood Products, Supreme Court talked about a theory called intergenerational equity, where the court observed that the present generation has no right to deplete the existing forest and leave nothing for the next and the future generations. Which means the actions of the present generation are going to have an impact and they do not have the right to play with the resources which are meant for the future generations. Then in 1996, Supreme Court established a principle called polluter pay principle, wherein a company was causing damage by releasing wastewater in a village in Rajasthan, and the company held that the court held that the chemical companies which were polluting were liable to pay damages and costs to clean the pollution. This polluter principle has been there for last 30 years since 1996. Then, in the same year, in the case of Vellore Citizens versus Union of India, Supreme Court came up with another principle which is called the precautionary principle, which goes on beyond the existing damage and compensation, but it also mandates the polluter to pay and expands the precautionary principle to regulate future actions of the government to prevent such pollutions. Then the most notable case is of the MC Mehta, the 1997 case of the environmentalist MC Mehta, who also got an Magsaysay award for this. And Supreme Court came up with a theory called public trust doctrine, where the court concluded that any use of natural resources or environment would not be permitted unless the court find it's necessary in good faith for the public good and in the larger public interest. Now, this case of MC Mehta, which started in 1997, is still continuing for the last 30 years. And many may not know that many developments in the Delhi NCR are being done through the same ongoing litigation, whether it was the BS3, BS4 of the various vehicles, the ban to the diesel petrol after a age, or the GRAP 3, GRAP 4 rules we see, or the ban to firecrackers. So this litigation is become like the master litigation or the mother of all cases for the Supreme Court. And this case has been ongoing where the environment is being monitored. A separate body called COQM has also been created as an authority to regulate the pollution in the Delhi NCR area. Then in 2010, a National Green Tribunal dedicated for this purpose was created to fast track disposal of environment protection cases. And in 2010 itself, in the case of Samta versus Union of India, the NGT relaxed the concept of locus standi to allow a wider base, which means not just an affected person, but any aggrieved person would also justify any person who has an interest in the environment to approach the court. Then very recently, I mean last month only, Supreme Court in the case of where the forest had been encroached in the state of Assam, the court held that encroachment upon forest land has emerged as one of the gravest challenges confronting environmental governance in the country. And the constitution cast a clear and unequivocal obligation upon the state to protect the forest and environment. Then again, last month, in the case of Rhythm County versus Satish Sanjay Hegde, the court has upheld the power of NGT to employ the project turnover as a relevant yardstick for determination of environmental compensation. And subsequently, the Ministry of Forest, Climate Change and Environment Protection we have now created a rules, which is Ministry of Environment has notified Environment Protection Fund rules, which operationalize the polluter pays principle through a structured fund mechanism. Again, in another judgment, the National Green Tribunal has held that damage to environment should be equated to any other heinous criminal offense like homicide. It cannot be treated as a lesser offense. Now, what is very important, because we are sitting in a university, that apart from the litigation, both in India and abroad, the role of youth in this climate litigation has been very significant. There was a major case in Uganda in 2012 where the youth related litigation triggered. Then in 2017, Ridhima Pandey, a 9-year-old girl from Uttarakhand, filed a case before NGT challenging the government inaction on climate change. Then again in 2018, the Colombian Supreme Court was approached by around 25 young people over the issue of deforestation in the Amazon area. And in 2020, again, in United States, 21 young plaintiffs in the case of Juliana versus United States, they argued that the US government's fossil fuel policy and inaction in the field of climate change is affecting the public policy doctrine. So what I mean to say is that these are some of the cases that were reported not only in India, but in the global, where they have tried to shape, the climate litigation has tried to shape some of the media narrative. And now we have a new kind of a PIL, which we call as public environment litigation, which is recognized as PEL. But what is important is the media framing of climate change. Because the way the narrative is to be framed, it will change the public perception and understanding of global issue. The courts also indirectly expect the media to translate the court action and decision for larger public awareness. The practice of storytelling in a media narrative have a very important role to play, which will involve all the stakeholders, whether it is the lawyers, the activists, the NGOs, or the courts. As I told earlier, that even if they are unsuccessful in court, a climate lawsuit can serve as a source of inspiration and knowledge for future. But what we have seen, there is one challenge in climate litigation, that our judicial system is so overburdened, and the climate litigation also involves certain technical issues. So sometimes resolving those issues is not easy. That is where the alternate dispute resolution, like the mediation, come into picture, where the stakeholders can be encouraged to mediate certain issues and settlements can be arrived outside the court, which are binding on everybody. And now with the AI into picture, the AI can be used to leverage the ADR. The government came with the Mediation Act 2023, which is a very important piece of legislation. And as our Prime Minister has described, that this Mediation Act is the link between the modernization of our tradition, because mediation has been there in our tradition since Mahabharata times, when Lord Krishna is believed to have attempted to mediate between the Pandavas and the Kauravas. And when the mediation failed, we know the outcome of that. And this Mediation Act also brings with it something called community mediation. Before this act came, community mediation was also attempted in the Ram Janam Bhoomi litigation, where the court had referred the matter to mediation between the stakeholders. The mediation was not successful, but the seed of the community mediation were sown, and now it has been legitimized with the Mediation Act 2023. Before I conclude, I can only say that the climate litigation is not an easy litigation. But climate litigation is a preferred litigation for the media. Because what does media look in a litigation? Like a movie story, everybody in the media looks for a hero. And in these climate litigations, sometimes the hero is a villager, sometimes the hero is a tribal, sometimes it's a student, sometimes it's a scientist, sometimes it's an NGO. And every time, every time it's a David versus Goliath story. Somebody is fighting against the government on one hand, against the corporations on one hand, and all they need is the public support who can back them. And that is where the media comes into picture, and especially with the media in India becoming more and more of corporate media and not the fourth pillar as it used to be. The focus is now changing and diverting to the alternate media, which is the social media, where the citizen journalists have taken upon themselves to post things on their social medias, on their Twitters, on their Instas, and which is generating a chain reaction. So on that note, thank you everybody.
You, Advocate Jitendra Gupta, for this great discourse. Before we go to the next session, which I would request the patron chair to say a few words. The patron chair, Professor Ajay Ranga, please.
Very good afternoon, everyone. First of all, I would like to congratulate to the Professor Jyoti and her team for organizing this international conference on this wonderful topic. Narrative in the field of law, in a legal field, is again a very important part of our society. And these narratives, they sometimes are good and sometimes they are very bad. They are very bad for the impartial justice. For justice, I would say. Because if somebody has created a narrative, because of any reason, one judgment has been passed, the advocate on record, the earlier speaker was talking about the Aravali judgment. The judgment was something different, and the narrative of the judgment was spread was entirely different. That has created a insecurity among the society. And the impact of that insecurity was the revolution by the public, the revolt by the public. And again, the justice was affected because of that narrative. Any case you might have heard in general, when the matter is under litigation, the matter is under investigation, the officials and the media people, they are prohibited and stopped from making any public comment. They are being stopped from creating a narrative, a public perception. And the judicial officers, they are the part of the society. Their mind, their thinking, that is being affected, and that may affect what the public is thinking about it, what the document is thinking about. Then the judge has to think with his or her rational capacity. And because of these narratives, because of the public perceptions, the justice or the judgment, they can be affected. And because of that reason, it is strictly stopped and prohibited that no news will be published. They cannot enter into the legal complications. They cannot enter into the social complications. They cannot enter into the other complication relating to any matter unless and until it has been finally decided by the court. You might have heard very unfortunate incident, this Damani rape and murder case, Delhi gang rape case, which is popularly known as Delhi gang rape case. In that case, after that incident, the entire society started agitating. Huge hue and cry was made. Commission was constituted by the government of India to deal with such kind of heinous crime. And the demand of the public was that there should be a death penalty in case of rape offenses. But Verma Commission didn't do it. I still remember a quote of that time cabinet minister Sri Pawan Bansal ji. Media asked a question to him, why your government is not making death penalty in rape cases? There, he said, yes, I'm agree with the resentment shown by the public. And because of the resentment and the public perception, we should have it. But what will be the implication of this kind of rule and law? Is rape offenses eliminated from the Arab countries where death penalty is for the rape offenses? Is it eliminated from that society? It is still there. It is happening in those societies as well. Secondly, he said that the sex ratio in India is disturbing. And that is not good. Women are constituting almost 50% population of the country, but still they are victimized. And if this punishment of death penalty will be incorporated into the all rape offenses, then today a rapist is committing rape, which is a heinous offense. But at least leaving her to live life, living alive to the victim. But if this law will be incorporated, then they will ensure rape after rape, they will ensure that the victim must be completely destroyed. No evidence should be left because the survival of the victim will be the death of the wrongdoer, the rapist. So if this kind of complication or this kind of law will be created because of the public perception, then in that case, we will put the life of females on stake into the society. Because of the limitation of resources with the state. State cannot do it. But both the things, public perception sometimes change the law and sometimes law change the public perception. For example, there was a time in our society when the sati partha and the child marriage was considered to be the matter of virtue. But law was made because of the sati partha and the child marriage was prohibited. Maybe after a century, the public perception has been changed. Now you can see how many girls are there or children they are getting married at the age of below 18 years. I'm not I don't believe it. Reason being, maybe you must have some direct information, but whatever the record of National Crime Record Bureau and these official records they are saying, it is not as per. If you say that it is more than 50%, I would like to say how many people of us sitting into the hall, they have experience in our neighborhood, in our relations. How many people they have got married at the age of below 18 years? Same is this. I can understand maybe in remote areas, maybe in tribal areas, maybe in rural areas specifically, but that is in rarest of rare cases. That is not frequent. I myself also belongs to a remote area, a village. It is not happening. People are very much aware about these things. But sir, still but still that is not 50%. That is not a 50%. And moreover, that 15% is exceptionally in states. That is not in a routine matter. That is not general. And because of that reason, there was a time when girl education in our society was not permitted. It was not permitted, and it was not allowed, not only allowed, but it was considered to be heinous crime or crime into the society. But now today you can see what the parents are doing. They are sending their daughters to the institution forcefully, even if they don't want it to study. And the result of this is you can go to any college, you can go to any higher education institution, any university. Almost more than 50% population is girls' population. That how law is changing the public perception, and how the public perception is changing the law. You can take example of the new concept of live-in relationship in our society. This is not, still it is not based on any law. We do not have any substantive law on this matter till date. But our honorable Supreme Court, because of through different judgments, they have recognized this kind of relationship. They are protecting this kind of relationship. And now the society is compelling the law to develop into different matters. There was a time when adultery was in 1860, adultery was made an offense in our country by the Britishers. But they themselves were not having the same incident as an offense in their country. But now today, because of change of the social perception, social sentiments, the law has been amended and adultery is no more an offense in our country. So this is how law is being affected by the perception, and both law create the perception as well. With these words, once again, I would like to thank to Professor Jyoti and her team for inviting me here and organizing this conference. Thank you very much.
Thank you, Professor Ajay Ranga, Professor of Law, Punjab University, and Registrar YMCA, JC Bose University of Science and Technology. Professor Ranga's discourse was spun around the social evils and how, the way they are portrayed in narratives may make us even participate in those social evils. He was talking about sati pratha, he was talking about child marriage, and how our society encourages these practices because of the charming, because of the glorifying narrative attached to such old customs that perhaps were not also probably very benign. Thank you, sir, for your enlightening discourse. I would request Professor Prasananshu to just say a few words because because Professor Prasananshu, who's the session chair, he wants to say something, reflect somewhat on what Professor Ranga has said. And I would really urge Professor Prasananshu to stay till the end because we have the Jhulna performance lined up and I'm not letting him go so easily. So I will allow, of course, we have to welcome him when he wants to speak. So he's going to address you, and then Professor Jyoti K. Verma, please.
Just, I think, comments on Professor Ranga's and Mr. Gupta's presentations. Professor Ranga, it's always a pleasure to listen to an erudite professor of law and a practicing lawyer. It was really very enlightening. I am reminded that I am guiding a PhD on environmental issues, environmental law at the moment. And also what you said is very, very relevant, very thought-provoking, very exciting. And I connect it with law and culture, the field of law and culture. Like what you said, that the law is driven by the opinion of the people. Of course it is. Law is nothing, according to me, but a solidification of the culture. It is what the people want, what they believe is right and wrong. You mentioned that sub judice matter is usually it is it is prevented from getting into discussion. The narrative, the discourse is limited. That is true. But if we look at the other side of it, it is my experience, and we all can observe it, that even in the Nirbhaya case, the case you mentioned, ultimately the age of majority was modified. The act was modified. How it was modified? Because of public demand. People said, and it was in the discourse, in the media discourse, that people who commit adult crimes should be tried as adults. And that brought about a change in law. So this is also the other side of the coin. One side is there, of course, that sub judice matter cannot be discussed. So that was wonderful. I feel really thrilled and excited upon every point, including the law of adultery, which was a patriarchal law, and how it has changed, what could be the history of it. I think the history was colonial tradition, and now we are aligning more with the Indian traditions in the law. That is the change. Thank you very much. Madam, can we have the next speaker now?
Thank you, Professor Prasannanshu. And when you have insights, then you want to exchange them. I do understand. Professor Jyoti K. Verma, he is now eager to take on. Sir, please, the dais is yours.
Will you please help in? Yes, this is it. Give the full screen. Yes, thank you so much. Good afternoon, everybody. My presentation will give slight change in the flavor of the discourse which you have been hearing since morning. I shall speak on a recentering of Indian literary criticism through Indian knowledge system. I feel that the time has come when we should come out from the stage of mere resistance to make our voice vocal, to make our voice global, worthy to be acknowledged worldwide. Next slide, please. Therefore, my presentation will argue on the line that Indianness does not lie only in showing resistance, only in showing resistance to the Western dominance, but also lies in the meaningful engagement or lies in evolving a constructive engagement with Indian knowledge system, its aesthetics, its philosophy, and its epistemology. Next slide, please. Therefore, if we recognize Indian literary criticism through IKS, we will be able to provide alternate epistemological foundations we will be able to offer a universal yet culturally rooted theory of aesthetic experience, and we will be able to contribute to decolonial and pluralist intellectual movement. Next. We all know that there is a difference between the British model of education and the Indian model of education. We know it very well. The famous minutes, rather infamous minutes of Lord Macaulay of 1835. And therefore, the knowledge transfer in the British model was deeply embedded in power control and dominance. The design was to produce compliant subjects. It was propagandist in nature, whereas Indian knowledge transfer was fundamentally ethical, relational, and participatory. The Guru Shishya Parampara was based on Seva, Samvad, and Sah-Astitva. So it represents epistemic compassion and civilizational wisdom. Next, please. We know that Indian knowledge system depends on or integrates different intellectual schools of Nyaya, Mimamsa, Vedanta, Buddhism, Jainism, and Kashmir Shaivism. It is much like, it is unlike Cartesian dualism, which separates mind and body. Indian knowledge system promotes integration, holistic appreciation of knowledge. Next, please. Therefore, I call the Indian literary criticism a comprehensive theory. Why comprehensive theory? Because, see, I always considered, in the previous slide I had shown it, I always considered in India as a civilization. I don't simply call India or treat India as a nation state. I treat India as a civilization because it encompasses the wisdom of the Vedas, the compassion of the Buddhas, the amalgamated visions and values of medieval saints, the inclusive governance system of the celebrated kings like Harsha, Ashoka, and even Akbar. And in the Indian Republic, modern republic, the pluralism of republic, Indian Republic. So it encompasses so many things, and therefore it is not just a line on the piece of paper drawn in 1947. I don't treat India. India is a civilization. Next, please. And we have to take care, rather, we have to go by the seminal thinkers, 4 basic seminal thinkers and seminal texts. They are Bharat's Natya Shastra, Avnev Gupta, Avnev Bharati, Anand Vardhan's Dhvanyalok, and Mamata's Kavya Prakash. It is not for nothing that I am trying to show these slides, because I want to ignite the mind of the young researchers. I want to set fire in their mind to come forward and not only simply align or imbibe or imitate the Western literary criticism, but also learn something, project from the Indian knowledge system. Next, please. Just a quick glance at the progress of Indian literary criticism in India. And I have divided it into 4 phases. In the first phase, I find that this phase was how we were treated, how we were marginalized, how we were not given that kind of due recognitions. It is just a kind of prejudice. So
they treated our literary criticism, our literary foundations as mystical, as abstract, and not objective. Vikachari has very vociferously argued that if you treat Bharat ambiguous or Bharat mystical, I can also treat Aristotle to some extent mystical. Next, please. On the Indian side, this phase was a phase of negotiation between Western forms and Indian sensibility. And this was the revisit to Sanskrit treatise. We know that it was the phase of Indian Renaissance. And we are aware of the clarion call given by Dayanand Saraswati back to the Vedas. Next, please. So it was phase of epistemic superiority. Somehow or other, we cannot ignore it. And from Indian side, we were left with no choice but to have epistemic inferiority. Then we move to, next please, phase 2. This phase is the phase of comparative equivalence. This is from 1900 to 1965. So we started showing that we also have what you have. Next, please. So parallelism, we started drawing parallelism for rasa, aesthetic emotions, and so many concepts, dhvani, alankaras. And these concepts were given parallels articulations or from the parallel terms from the Western literature. Next, please. Next. Now the third phase. This phase is from 1970s to 1980s, and this is the phase of assertive theoretical confidence. Now we started developing some kind of confidence in this era. And so Indian theory presented theoretically superior in many areas. Next, please. And from this stage, we also have what you have. We are like you. We are not only different, we are more refined in structure. Next, please. Next. Now, phase 4. The phase 4 is 21st century. And here we have to establish our civilizational autonomy. And therefore, the emphasis is always on the decolonization of mind, epistemic sovereignty, indigenous framework, and knowledge pluralism. My contention in my presentation today is that the time has come when we have to show our epistemic sovereignty. From epistemic inferiority, we have come to this epistemic sovereignty. And for that, we have to change our mindset. What Ngugi Wa Thiong'o once said, the celebrated Kenyan writer, that we have to change our mindset. Liberation of mind is most important thing. So we have to change our mindset. So decolonization of mind, for decolonization of mind, I make an appeal to all the researchers, the young researchers of Indian universities, that we have to decolonize our syllabus also. Yes, please, quickly. Next. Next. This is important. On every step, just by talking that we have to decolonize, our decolonization is not taking place even in the Indian university. We, the teachers, are still responsible. We have to introduce, we have to bring parallels. While introducing a course in the cultural studies and the text by the Stuart Hall, we have to think to introduce the Indian thinkers like Ashish Nandi, D.D. Kosambi, and even the A.K. Ramanujan. So we have to think in these terms also. And therefore, what is required is to develop more and more knowledge of the Indian knowledge system. Yes, please. So even in translation, I have given this, but this due to the paucity of time, I'm not going into the details. Even in the translation, we can from the established theorists like Jacobson and Nida and Catford, we can talk about Panini's grammar and the translations. We can talk about Mamtas and other philosophers of Indian philosophy, Indian Sanskrit literature. Next, please. Next. Next. So these are the basic texts which I recommend all the Indian students to go through. So thank you very much. This was my contention to ignite the mind of the young researchers to recenter the Indian literary system, Indian literary criticism by exploring Indian knowledge system. Thank you so much.
Thank you, Professor Jyotike Verma. This was indeed an enlightening lecture. We were really elated to hear about Indian civilization from your expert session. We look forward to hear you more in the coming days. Okay. Now we would like to invite Professor Ghosh for his remarks. We would definitely would like to hear from his discourse what he has to share with all of us. Yes. We welcome you, sir.
Good evening, ladies and gentlemen. It was a pleasure listening to such important discourse, and I think the biggest success of the conference is in choosing a theme where the message, the storytelling, and the method, the message, and the public support that our learned advocate had mentioned about. But what I feel is like, I would rather than go ahead with the deliberations, which were very erudite, I would like to say that there are certain things, that what is storytelling all about? Whom are we addressing? Who's addressing? If we look at, say, a ghazal by Sudarshan Fakir, in that famous ghazal you have वो मोहल्ले की सबसे पुरानी निशानी, वो बुढ़िया जिन्हें बच्चे कहते थे नानी, वो नानी की बातों में सदियों का फेरा, बुलाए नहीं कभी भूल सकता है कोई, वो छोटी सी रातें, वो लंबी कहानी. This is the effect of the storytelling. And this storytelling becomes so important because if you have to touch the people's heart, you have to talk about stories. I mentioned Sudarshan Fakir. Now everyone has heard about Arundhati Roy in a book which everybody is aware of, The God of Small Things. One may not be aware of the statement she makes. Frankly speaking, I was not very much in love with that book, but the one particular paragraph where she tells about good stories. And she says that the good stories have no secret. It is a tale that you have heard before and a story that you want to hear again. So when the message has to be repeated, because otherwise in this deluge of the social media and invasion of technology and other things, I will just refer to one small episode, where the message to the medium, to the masses, how it is transferred. All of us here are aware of the song Bande Mataram, which is almost a kind of a parallel to our national anthem. And when Bankim Chandra wrote this poem and it became a part of Anand Math, it was just in a page which was first published in Bangadarshan. Nobody was aware of it. And then in 1896, when Rabindranath Tagore sang that song in the Indian National Congress of 1896, people came to know that yes, yeah, this is Bankim Chandra's song and very famous and all that. But not until 1906, when Bankim Chandra published this poem in Karm Yogi, that Bande Mataram became a national word for stirring the masses. And it was today, and when in the Bande Mataram he was talking about, and if you look at Aurobindo's background, when his father took his two sons, Aurobindo and his father Krishnadan Das, took them to London, he gave instructions that my children are not to have anything to do with any image or reflection of India. They should be kept away from India. And look, that Aurobindo comes back. And he revives the tradition of all the ancient times. And then he presents in his translation. It was not Bankim Chandra's poem which became more famous. It was the translation which Aurobindo did, which drew the attention, and the power against Aurobindo was the power that had actually decided that this man must be executed and got rid of. So this Aurobindo brings Bande Mataram into the context, and Bande Mataram becomes a rallying song against the powerful British who were opposing and ruling India. So what I'm trying to say is that what we must focus upon is that whose message? Today, if we are talking about, the advocate talked about the public support and the climate litigation. No matter how many thousand pages of public litigation and everything, the public becomes aware. But the story of Gaura Devi, a 56-year-old widow who hugged the trees when the tree fellers had come to cut the trees, that became an international movement, which was the Chipko movement. And you see, when the words and others have to be translated, and you have a target audience, and you have some kind of a vision for humanity, that is where this the success of this kind of a conference would result in. Because unless you do a deliberate debating on what needs to be told, and you see, merely by writing papers and talking about it in the conference and the Department of English and J.C. Bose University should really develop this as a stepping stone, and they should plan out, how, okay, these are the certain messages, not have a too ambitious dream, but how these messages can be put across to different media personalities, houses, and other things. Because today, if you talk about, you see, what lasts longest is obviously something which touched the people's heart. And even William Shakespeare made it clearly, was sort of highlighted by Samuel Johnson, who wrote in his preface to Shakespeare that what lasts the longest and pleases the most, that is what is all storytelling about. So I hope that after going back home, all these youngsters who are sitting there, they will think of the stories, which will never. And if you have heard the stories again, you want to hear them again. And that is probably what is storytelling all about.
that, Professor Pool Kumar Malik from University of Lille, France. He's a marketing